The Equal Protection Clause of the 14th Amendment opened the door to court action of many different kinds. Could women be discriminated against because they were women, was the question asked. The early court cases undermined arguments for protective labor legislation for women only. Velma Mengelkock, for example, wanted to work overtime in her factory job. Widowed and with 3 children, she wasn't making enough money to support them. But California, where she lived and worked, banned overtime work for women. She turned first to the EEOC, which was still puzzling over the meaning of sex discrimination, and then, with the help of Pauli Murray and others, she brought suit in 1967. It was a landmark case, lifting laws that prohibited women from working overtime if men could do so. At the Southern Bell Telephone Company, women were denied access to jobs that required the lifting of weights over 25 pounds. Lorena Weeks, a Georgia resident, sued the company with the help of the Now Legal Defense Fund. A 1-year-old child, Weeks argued, could often weigh more than 25 pounds. She could do the job she wanted. When Weeks won her case, she pushed the EEOC into issuing guidelines that prohibited sex-based weightlifting limits. Another piece of legislation that deprived women of jobs fell to the ground. In a breathtaking series of court cases that firmly implanted the notion that women could not be treated as a separate category under the law on account of sex, emerged in the early part of the 1970s, and more such barriers fell. In one case, the court declared that a woman could not be denied the right to execute her son's estate just because she was a woman. In another, the court ruled that a female member of the military was entitled to the same benefits as her male peer. Then again, the court decreed that a woman's Social Security contributions should provide survivor's insurance under the same terms as that of men. And on it went. In Phillips versus Martin Marietta Corporation, a unanimous Supreme Court held that employers could not refuse to hire women with small children for jobs in which they hired men with small children. 2 years later, it decided that an employer could not pay women who worked on a day shift less than a man who worked the same job at night. The EEOC strategy shifted in this period to one of representing whole groups or classes of plaintiffs rather than individual women. The EEOC sued American Telegraph and Telephone Company in 1973 because the company refused to hire women to do well-paying outside jobs. AT&T had long hired women to work at inside jobs as telephone operators and to do various sorts of desk jobs. But the company refused to consider women for such jobs as climbing telephone poles and repairing telephone wires. The EEOC went to court on their behalf, and after grueling negotiations, AT&T settled in 1973. After about 4 years, the EEOC and AT&T together assessed the results of the agreement. It's a fascinating coda. They discovered that most of the newly hired women had only held their jobs for a few months before quitting. Looking for explanations, the EEOC discovered that while AT&T had certainly given women a chance, the company hadn't provided women with appropriate clothing, boots that fit them, or equipment that they could manage. The EEOC insisted that AT&T then replace its old wooden ladders with lightweight galvanized aluminum. It insisted that women be provided with clothing, boots, and toolkits that fit their generally smaller bodily proportions. With these benefits, women managed to hold on to the outside jobs. Taken together, court decisions altered the expectations of women for equal protection. With sex considered a suspect category, the courts determined that men who harassed women on the job, or denied them mentorship and training, or refused them promotion, were guilty of discrimination. Remedying these situations didn't solve the problems of women, but they made their lives easier.